Sir, I beg to move that the bill further to amend the Copyright Act 1957 be taken into consideration. Sir, we are in the midst of a new era, which I call the digital era. And in this new digital world, the nature of rights of various stakeholders need to be looked at afresh. As technology moves forward and new innovations give scope to accessing entertainment to ordinary people in this country through the digital world, we need to understand its complexity and to ensure that key stakeholders are protected and are conferred with rights so that they can take benefit of the new technologies in this new era. It is in this larger context that I am moving this bill for the consideration of this House. A time comes in the life of a legislation that we need to move away from the past and embrace the future. And we've been witnessing a situation in the past where certain key stakeholders have had access to rights and other stakeholders who are the creators of intellectual property have been denied that access. We are in an era where the visually impaired can now use technologies to empower themselves. We are in an era where the resolution of disputes between key stakeholders must be addressed and a permanent mechanism be created for the resolution of those disputes. We are in an era where international treaties to which we are signatories, which hold the field, persuade us to bring our laws consistent with those international conventions. Sir, I'd like to address this issue in 7 parts, because I would not like to take the time of this House to deal with individual sections. But there are 7 broad areas which are reflected in these amendments that need to be addressed. Number 1, the rights of authors and music composers, who are the real creators of intellectual property. Number 2, the rights conferred to the visually impaired. Number 3, extending the compulsory license regime to unpublished works other than orphaned works. Number 4, having a new regime of statutory licenses in respect of cover version recordings and a statutory license for broadcasters. Number 5, bringing the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty and ensuring that our Copyright Act provisions are consistent with those treaties, so that we enlarge the right of performers. Number 6, impose certain exceptions and limitations wherein we stipulate that certain acts will not deem to be infringement of the copyright law. And number 7, some punitive actions for those who still seek to infringe the copyright law through new technology. These, sir, are the 7 broad areas which are dealt with in these amendments. And I would like to address each of these areas succinctly for the consideration of this House. First, sir, protection of authors and music composers. So, as you know, the regime that has existed in the past has been that the real creator who creates that intellectual property, like the wonderful artist who played the santoor the other day in Central Hall, Shiv Kumar Mishra Sharma. Then Shubhaji, who enthralled us with her music and her vocal performance. These are the people who are the real creators and form the backbone of the artistic world. They are the creators on whom the business community relies for their creativity to take the entertainment industry forward. And in the past what has happened is that those who have money power have sought the assignment of their intellectual property unconditionally to themselves, and then used that assignment for the purposes of exploiting that work not just in cinema but through other mediums. The result of which has been that the artist who is the creator of intellectual property gets no share of the profits. That has been the legacy of this industry in the past. We want to correct that legacy. We want to ensure that the author and the music composer and the artist has equal share in the profits that the assignor makes through other mediums. And it's in that context that we have amended section 17 of the Act, wherein we say the following, and we put a proviso in that section which reads, provided further that in the case of any work incorporated in a cinematograph work, nothing contained in clauses B and C shall affect the right of the author in the work referred to in clause A of subsection 1 of section 13. So the right of the author is preserved. The right of the author is protected. Similarly, in section 18, which deals with assignments, we've added another proviso, which says, provided also that the author of the literary or musical work included in a cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of copyright for the utilization of such work in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall, except to the legal heirs of the authors or to a copyright society for collection and distribution, and any agreement contrary to that should be void. What's the purpose of this? The purpose of this is that in the past, these rights used to be assigned. The author had no share in the exploitation of that work through another medium. And now we are ensuring that the author has equal share in the distribution of profits made by the assignee through another medium. The same is being protected with respect to the literary or musical work included in a sound recording. So the author is being protected, and the music director is being, and the music composer is being protected, so that they have equal share in the profits that will be earned through other mediums. We've also decided to determine the mode of assignment. which is reflected in section 19, wherein we say, no assignment of copyright in any work to make a cinematograph film shall affect the right of the author of the work to claim an equal share of royalties and consideration payable in case of utilization of the work in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall. And the same applies to sound recordings. The idea being, you can have the work assigned, but you cannot have the royalties assigned. You can use that work through other mediums, but there can be no assignment of royalty, so the author and the music composer will share royalty with the producer, with the assignee in equal terms. That's really the concept behind these amendments, protecting the right of the author and the music composer. We've had to therefore amend sections in the Copyright Act in respect of copyright societies, wherein we are ensuring equal representation of both authors and components and owners of rights in copyright societies, so that the member of the copyright society is not limited only to producers. There is equal representation of the creators of copyright as well as those who exploit the copyright. And therefore we made amendments in section 33 to that effect, and I will quickly refer to it. Provided further, and this is an amendment to section 33, we've added a proviso, provided further that the business of issuing or granting license in respect of literary, dramatic, musical and artistic works incorporated in a cinematograph, film or sound recording shall be carried out only through a copyright society duly registered under this Act. Provided also that the registration granted to a copyright society under subsection 3 shall be for a period of 5 years and may be renewed from time to time before the end of every 5 years. Provided further that the renewal of the registration of a copyright, and this is important, copyright society, shall be subject to the continued collective control of the copyright society being shared with the authors of works in their capacity as owners of copyright or of the right to receive royalty. So the authors are now sharing the ownership of the copyright. They are equal partners in this enterprise. They equally share it. And therefore, the copyright societies which collect the royalties, collect the monies, will share those monies equally with the authors. So that's the amendment that was required under the Copyright Act. And that we have done, sir, and so that the authors and other owners also are equally represented in these societies. We wanted actually to give this right also to the principal director. So remember, the music composer, the author, the photographer, the choreographer, there may be many elements in this who have contributed to the industry, who are also creators, and the actors, and of course the director. I mean, director has an enormous role to play in the making of a film. In fact, he is perhaps, according to me, the principal creator. And I very much wanted that the principal director should actually share in the same profits. But unfortunately, there was a feeling in the standing committee that the time is not right for the Indian industry to give that equal share to the director. And therefore I bowed to the wisdom of the standing committee, and therefore we are dropping that particular amendment that I have proposed, which intended to give those rights to the principal director as well. Therefore, we've had to amend section 2 to ensure that this does not happen. That right is not given to a principal director. We've had to amend section 17 and section 26 so that the principal directors do not share, have no share in the profit. So this is the first issue that I wanted to place before honourable members of this House. The second relates to the visually impaired, because I think new technologies are now out there for the visually impaired to access, to empower themselves, to educate themselves, to participate in the life of the nation, to be contributors to society. And therefore we've had to give those rights under 52(1) small ZB in brackets, and I will just indicate to you what those rights are. We are now saying that the adaptation, reproduction, issue of copies or communication to the public of any work in any accessible format, by any person to facilitate persons with disability to access to works, including sharing with any person with disability of such accessible format for private or personal use, educational purpose or research, or any organization working for the benefit of the persons with disabilities, in case of the normal format, prevents the enjoyment of such works by such persons, provided that copies of the works in such accessible format are made available to the persons with disabilities on a non-profit basis, but to recover only the cost of production, provided further that the organization shall ensure that the copies of works in such accessible format are used only by persons with disabilities and takes reasonable steps to prevent its entry into ordinary channels of business. So we are protecting those visually impaired and giving them the right for access to any format of technology for the purposes of their empowerment. And no fee, no royalty, no nothing can be charged. Of course, if there are a set of persons which want to use this material and provide to the visually impaired for profit, in that case, they will have to take a compulsory license, only in those cases. Otherwise, the works can be used in any format, and this is reflected again in section 31B, which states as follows. (31B) says, any person working for the benefit of persons with disability on a profit basis or for business may apply to the Copyright Board. So the Copyright Board is bound to grant them a license, and then of course this activity can be done for profit as well. That's the second issue that I wanted to place before distinguished members of this House. The third is granting a compulsory license under section 31A, sir. This is a new section, and we are now, as I indicated in my opening intervention,